So welcome to this day of celebration of our distinguished colleague, Professor Lawrence Friedman. I think he is the man of the hour, and he needs no introduction. In fact, an enumeration of his many books, including the two that we're talking about today, and his innumerable scholarly awards would take us the entirety of the two sessions. So I will refrain from doing that and just say that we will have many opportunities to toast him and to celebrate his incredible achievements during the course of the day today. This panel right now is on his book co-authored with Joanna Grossman called The Walled Garden. And we will have several distinguished commentators, as well as Professor Grossman, who will lead us off to give a brief summary of the book. Professor Grossman is the inaugural Ellen Solander Endowed Chair in Women in the Law at SMU Dedman School of Law in Dallas, Texas. And she is a graduate of Stanford Law School and began her career as a clerk for Ninth Circuit Judge William A. Norris. She's published many books on sex discrimination and workplace equality, as well as other issues. And these include her book 9 to 5, How Gender, Sex, and Sexuality Continue to Define the American Workplace, as well as another book co-authored with Lawrence called Inside the Castle, Law and the Family in 20th Century America. Next on the panel, we will have Manuel Gomez, who is the Associate Dean for Graduate Studies and Global Engagement and a Professor of Law at FIU Law School. His research has earned important awards, such as the Law and Society Association's Dissertation Prize, the Richard S. Goldsmith Award in Dispute Resolution, and a prize awarded by the Venezuelan Studies section of the Latin American Studies Association. Following Professor Gomez, we will have Stuart Banner, who is coming from UCLA Law School, where he's the Norman Abrams Distinguished Professor of Law. He's a legal historian who has written almost as many books as Lawrence, and he has received fellowships from the National Endowment for the Humanities. I'm sure he'll make up for it in time. The John Simon Guggenheim Memorial Foundation, the Fulbright Scholar Program, and the Woodrow Wilson International Center for Scholars. He's also a Stanford Law grad and clerked on the U.S. Court of Appeals for the Ninth Circuit, as well as for Justice Sandra Day O'Connor of the U.S. Supreme Court. And our final panelist is Gilad Bashar, who is an assistant professor of law at Temple University Beasley School of Law. She was previously a visiting assistant professor at Villanova, and prior to Villanova was a research fellow with the Stanford Center on the Legal Profession and a Stanford Law School postgraduate public interest fellow at the Center for Justice and Accountability in San Francisco. She holds her JSD from Stanford, and prior to coming to Stanford, she clerked for the Israeli Chief Justice and worked as an associate in Israel. So please join me in welcoming these distinguished panelists, and we will hear from all of them and then have a chance for questions from the audience. Thank you so much.
Yes, you're supposed to clap. He wants to know if he should clap for himself and his panel. You should know that the first words he said to me this morning were, "I can't believe you're picking me up in a car with Texas license plates." So we'll see how the day goes from there. So this book, I'm going to try to be the briefest of the panel because I, of course, would rather listen to other people talk about this than myself. But this is the second book, as Bernie mentioned, that Lawrence and I wrote together. The first was a book on family law called Inside the Castle, Law and the Family in 20th Century America. This was published in 2011, and if you know Lawrence, then you know that way before 2011, he was calling to yell at me about why we hadn't started a new book yet, and we weren't going to surely just sit on that one. He had proposed the idea of doing a book on privacy law, which for years we called Outside the Castle in all of our communications. So I have emails going back 10 years talking about Outside the Castle. Where are we on Outside the Castle? And then we ended up not calling it that, but that is still what it is to me. So this book is an exploration of what we in American law and society mean by the idea of a right of privacy. We stipulate at the beginning, per Lawrence's very strict parameters that we do not talk about the constitutional right of privacy, except for a few sort of dismissive things in the introduction. We leave that to other people. What we try to focus on is everything else that privacy means in law and society. And if you were to read the book, you would find out it actually comes up in a pretty amazing variety of situations. So we focus on this core idea of the right of privacy as the idea of a right to be let alone. But that sounds like a very simple concept, but of course means different things in different places and in different contexts, right? In your home, being let alone might mean the right to have a really secret, unobserved sphere of life, right? A peeping Tom would feel like an intrusion, as would government surveillance or government invasion. But so might a bathroom without a door, or sharing a bedroom with someone you weren't married to. And some of these expectations are as old as time, and some of them are very modern, right? We have very different desires about privacy today than you might have had 200, 300 years ago. But what stays constant is this sense of people do have a certain consciousness of a right of privacy in a sphere, and that it is obvious to them where those lines are, even though it might not be obvious to the law. But those same people who expect to be shielded from view in their homes sometimes leave the house. Not anymore, but we used to leave the house.
Used to leave that.
Yeah, and when they do that, of course, they don't abandon their sense that they are still entitled to privacy, but it means very different things, right? So if you walk out on a public street, or come to class, or go to a store, you don't expect to be unobserved, you don't expect to be in secret, and yet you do have a sense, maybe what we talk about as an expectation of anonymity, that you can sort of go about your day without having somebody tracking you or writing down where you are and what you're doing, although of course that is exactly what's happening today. And we don't expect people to stand too close to us when they talk to us. We don't expect people we don't know to address us in conversation, right? We expect to sort of muddle through life with this sense of anonymity, and that really is an aspect of privacy, right? That you expect to both be able to be in public and also have privacy. Now, obviously, expectations around anonymity have changed greatly with technology and with things like terrorism, and we end up being willing to sacrifice certain aspects of that kind of privacy in return for a false sense of safety. And then we also talk about privacy as including something we call the right to evanescence, or the right to make the past disappear, that you can do things and then move on. And even if we're observed, right, as we go through life and people know what we're doing at any moment, they don't have a record, right, where they can keep track of that over time. And so you can make choices over time that make your past private, in essence, because you get to be who you are at that moment. Now, this too obviously has changed with modern technology, and this idea of a right to be forgotten or a right to be ignored is no longer something that we can take for granted. I know if I had to pick things that Lawrence says more often than anything else, one of them is, do you know that an email is never really gone, even if you delete it? I said, yes, I do know that. So all of these concepts that I'm mentioning represent one part of the privacy equation, which is sort of what we think about as the rights half. And we call it in the book elective privacy. And that is the people choose how much of themselves to reveal and what to keep private. Manuel, for example, if you're on Facebook with him, says he lives in Papua New Guinea, and he has chosen to project a false sense of residence in order to keep his real whereabouts private. But the right
Papua
itself,
New Guinea.
right? The right itself of elective privacy is about choice, right? About the ability to calibrate who you are and what people know about you and what you project to the world. But what we do in the book is also examine what we consider to be the other half of privacy, and that's the duty, right? And this is a part of privacy that doesn't get talked about very much. We always think about privacy as being a right, something we choose. But in fact, there are a lot of rules in society about things you have to keep private, where the law or social norms force you to be private about things that you might choose otherwise to share. And we call this mandatory privacy. And with both notions of privacy, privacy is as much a product of social norms as the law, and it's often very hard to tell where the line is, including to the point that we tell a story in the book about police in New York City who repeatedly arrest this woman called the Topless Woman of Union Square. If you ever hang out in New York, you've probably seen her and her top. And they repeatedly arrest her even though it is in fact not a crime to go topless in the state of New York. There's binding legal precedent saying you can take your top off. But the police keep arresting her, and they had to have an in-service training to sort of say, this actually isn't against the law. They had to explain that to the police, but that's actually indicative of a bigger problem, which is privacy is one of those things where the social ideas about it are really, really deeply entrenched and often eclipse the legal ideas about it. So the first 4 chapters of the book explore mandatory privacy. The first chapter, I will say, is pretty lit, everything you ever wanted to know about public nudity laws. And the underlying taboo on the naked body and the idea that sex is both powerful and dangerous, right? That men have to be covered in order that so people don't feel threatened, and women have to be covered so that men don't threaten them. But that we have all these rules built in about the naked body. We do a lot of exploration of nudists, and there's a lot of interesting stuff in there, and I don't have enough minutes to go through the whole thing. And then the second part of the book deals with these elective privacy issues, the right to be let alone. We look at such a wide variety of topics, so everything from spies and con men and bigamists, right? To what extent do you have the right to project a false life or a double life? To what extent can you be from Papua New Guinea and also Miami at the same time? Sorry, we're never going to
that's great,
stop
actually.
talking about this. And then we also talk about things like adoption secrecy and the closeting of gays and employment laws, and all of the different ways in which we can or want to make choices about what we project to the world. And in this section, there's also things like we do a pretty deep look at practices like upskirting and revenge porn, and one of the things that Lawrence and I we've always looked at all of these things and said, what's really happening here? What does the law say? What do the norms say? What do the books say? And I used to send him emails and say, close the door before you click on these links. And he would say, if I die in this office, they're going to come look at my computer and be sure that I'm a dirty old man. I was like, well, you are old, so just close the door before you watch these upskirting videos. But we had great fun doing this. And then the third section, sort of, we call the flight from privacy, in which we basically say, what now, right? We have some bedrock principles, some flux, some change, but also this modern era in which we really have a sort of complicated society in which people both simultaneously have very strong ideas about their ability to control their identity and their lives, and also like to vomit up their entire lives on the computer, right? And technology basically means that there are no secrets, right? If you want to know anything about anybody, just see me after the panel. I will tell you where to find it, or I'll find it for you. It's really almost impossible with technology. And so we look at some of the sort of modern conflicts and controversies about privacy in this sort of very unusual age of people really not being sure, right? Do they want to tell you everything or tell you nothing? And what about the fact that they can't? And this book was a good mix of Lawrence's knowledge of Victorian literature, every classic movie that's ever aired, and my obsession with celebrities, gossip, and social media. And actually, those things are sort of equally relevant to the story that we try to tell. Whether that's successful or not, I don't know, but I'm going to stop there.
So, am I the next one?
Sure. I don't know.
The one who lives in the most remote location? So actually, you need to know why Papua New Guinea. So when I opened my Facebook account, and it was at the beginning of Facebook, and it was I was in the kayak and canoe team here at Stanford with a bunch of undergrads, and they had Facebook, and they communicated through Facebook, and I didn't have an account, so I had to create one. And the profile asked you to state your hometown, and I had just read some, article somewhere that said that was about the one place in the world, the one zip code in the world that has just one inhabitant, and it was the Boku police post in Papua New Guinea, and I thought it was funny. So I guess I was, doing my Facebook thing, and I thought, well, now there are 2 people who are from Papua, and that was it. It was just meant as a joke. I never thought about it. I don't check Facebook that much. Facebook had like this peak, and then, I completely forgot about it. And I guess my aunt and other friends, still, or family or friends, still congratulate me on my birthday and things like that. And I check it like a year later. But then when Lawrence made the comment this morning, I had completely forgotten about it. He says, hey, what's wrong with you? You were from Papua New Guinea. He takes it seriously. And then he says, Joanna, we'll talk about this with you. And then she says, did you read my Facebook message? And I said, I don't check Facebook. I don't have it on my phone. She's like, well, I'll check it. And she erased it. Then it made me think why, aside from the joke, anybody would do that. And I did it honestly as a joke at the time, but it would also conceal where I'm from or where I live. It could be used as a privacy tool. In fact, I have a lot of colleagues who opened Facebook accounts at the time, and they probably still have it. And when you look at their names, but I think Facebook has taken care of that. Their names are, it's the middle name and the second last name. Or the name has been modified because they don't want to be found by their students, for example. They want to be found by their family members, that they use Facebook for limited purposes only. So in a way, even though, and you guys talk about this concept of maintaining or wanting to maintain your privacy at the same time when you want to be seen by others, which is one of the big challenges of our contemporary society, that it's not private that you want to show some, but to some people, and you want to control that. So that's the constant tension that we live in, and the constant tension that it explores, I think, so successfully. So I, the more I think about this Papua New Guinea anecdote, the more it makes it, interesting, and interesting as a starting point for this. You may write a book about it.
I was just
I don't
thinking.
know. We have to check how
Opening story in the
how
sequel.
many people live in Papua, claim to live in Papua New Guinea later on. I'm probably going to be taxed or something, or canceled by the Papua New Guineans saying, you are, impersonating. Or anyway. So now let's get serious. So I'm gonna say very briefly about 3 things that I liked about the book, 1 thing that I didn't, and then I'll make some quick remarks. The first thing I really liked about, I know him well. I know Lawrence more than, I like to say that Lawrence is my academic dad. My dad doesn't, I don't have the type of conversations that I have with Lawrence. And I haven't learned the type of things that I've learned, although I've learned things from my dad a lot, especially if he's watching. He's not. So anyway, I think what is the quintessential Friedman, and I guess by association the quintessential Joanna Grossman now, is the ability to collaborate with someone. And the reader who knows, I know more Friedman's scholarship than I know Joanna's scholarship, although I've read some things from Joanna that have educated me on fields that I have nothing to do with, that you read. And I know some of the Friedman. I know the Victorian references where, that's totally Friedman. But it's woven in a way that is seamless. And it's not just because you've been writing a lot together, but because the story it flows very well. So I think that collaboration is a very successful one. Sometimes you read collaboration, especially if you know the authors. If you don't know the authors, it's meaningless. You don't know, you may read, and we'll get into that, Prince Harry's book. And he has a ghostwriter, probably a really bad ghostwriter because the press is horrible. Anyway, but this is, I think, a very successful collaboration that is intellectually valuable, that gives Lawrence the safety not to be canceled, for example. And I'm saying it in a good way, because these are topics that are very important. It's very hard to write about that. It's very hard to write about, say, sex in a scientific way like they've written, with the frankness that without having, say, a female co-author. So if he had written this book by himself, it would probably be read with a different light by people who would say, "Who are you to write this?" And we get into stereotypes, and I think that doesn't happen here, in part because of that, the positive aspect of a collaboration. I don't think anybody's covering for the other, but I think it's just an example of how the current challenges of our society, rightfully so in some ways, get some break by a lot. These things exist and they're very good. It's good. We are the beneficiaries of that. So I think you save his life too when you tell him, close your door and things like that. Especially because, Lawrence, there is no right to evanescence, as that tells you from experience, right? So they were the weavers. There is an anecdote that the Friedman told me and my family a long time ago about these weavers from Madison, Wisconsin. You remember that?
Yeah.
Okay. So we're not going to talk about that, but I think you and Joanna had become the weavers of this very rich topic. You contextualize. So the first thing I like is the collaboration. The second is how you weave these topics together. There are these American cases, mostly American cases. They have some, it's sprinkled with some comparative stuff, but it's mostly an American. It's a book written by American scholars, especially about, or primarily about, what has happened in the U.S. There's some foreign references, but it's mostly for an American audience or for a foreign audience that wants to know more about the U.S. Some of the cases, I know, we know the technical aspect of the case, but to read those cases through a different lens that contextualizes them, then puts them, and I think this is a second contribution, to put them in the same boat as social norms and rights, but rights not technically construed, but rights as understood by regular people. I think that's a big value, because you could read, the alternative would be to read about all these cases in case books or in law review articles, and you get the technical answer or the technical description of what happened in the case, but you know very little about what transpires outside of the case, outside of the judgment by the court. So this is very valuable, and I hope, I was thinking about how somebody teaching from those cases could integrate. I guess you just tell the students, just have to read the whole book, because it jumps back and forth, and the cases are not important, and that's a big challenge, to use cases and just to devote one line to the case and then move on, because that's not what matters here. What matters here is a bigger thing. And the third thing, that's the third thing I liked, the contextualization. So it's the collaboration, the weaving, and then the contextualize it, and be able to jump back and forth between the black letter law and the law in action, the norms, social aspects, the morals, devote some time to what role religion has had, but not engage necessarily in that technical discussion. So I think that was very good. What I didn't like, it should be longer.
Yeah.
But you had to move on. I know Lawrence had to move on to the next book and to the mystery novel that he was writing on the side, and the recommendation letters and all that stuff. And Joanna was probably, had to grade and write another book and things like that. I wish it was longer, but I know there will be another one. And just the last point, because I'm a comparativist, and when I see, things from abroad or from other legal systems, I really, it brings a smile on my face to see that, this is mainly about the U.S., but the U.S. is part of the world, and then, some of the things that happen in the U.S. are informed, but things that happen outside. So I spent some time in Portugal last year in a Fulbright, and when this debate about abortion was taking place in the United States, and Portugal is a very conservative society. It's very Catholic, more than 90% of the population. It's not just listed as Catholic the same way as I'm listed as a citizen of Papua New Guinea, but they, probably more than half of the population, and actually the Catholic Church is very good at keeping tab on who list themselves as Catholic and who's engaged somehow, and that's a story for another day. So probably more than half of the population are, not just nominally Catholic, but really Catholic. But the debate about abortion, the right to, reproductive rights in Portugal, which took place about 25 years ago, was very, very different. They allowed it as a matter of law. The role of the Catholic Church, the formal role of the Catholic Church was to step aside because society had changed. And they acknowledged that. So instead of blocking, or instead of telling people this is wrong and you're all going to burn in hell, the official position of the Catholic Church was, let's step aside, society will evolve, and perhaps ironically they thought, well, we're going to save them at the end. Oh, I'm just saying this is my own addition, but that's a very interesting and very unexpected development, at least from an American, somebody who lives in the United States. That's very unexpected about a conservative society, to think that a conservative society would do that. It's very different from what anybody from this side of the ocean would think. And there were all these other, aspects when you were talking about privacy and when you were talking about what courts have done in the United States, that you look outside of the United States and you see a lot of those changes have happened, not by courts that are progressive occasionally and then there is a movement, but sometimes by changes in the legislature that require much more support, political support. And then judges, the struggle is different because then the struggle is that judges have to decide what to do with this new law that perhaps was not legitimate in the eyes of the judges. So the walled garden, it's very porous. The tiger is not entirely in the cage. There's a reference to tiger in the cage. I think there are other animals that are caged and not necessarily the tigers. So it was a pleasure to read it, and obviously this is a wonderful opportunity. Thank you.
Well, the walled garden this book has a publication date of April 2022. And if this was anyone else, I'd feel confident in describing it as Lawrence's most recent book. But since it's Lawrence, I thought, I'd better check on Amazon. And it turns out it's not his most recent book. The one you'll be hearing about this afternoon, Personal Identity in the Modern World, was published in August of 2022. So that one might be Lawrence's most recent book, but I have to admit, it's been a couple of weeks since I checked on Amazon, so it's possible that there's 2 or 3 more books now since then. Well, Lawrence was one of my teachers when I was in law school here, and that was 35 years ago. Of course, we didn't dare call him Lawrence back then. He was Professor Friedman to us. And I'll be honest, the reason is that he just seemed really old. I mean, he was older than our parents, and they were very old. Of course, I'm now older than he was then, and so I can see that it must have been an optical illusion, that he wasn't old at all. Now, when I read Lawrence's books, including The Walled Garden, I'm reminded of what he was like as a teacher, because the things that made him such a good teacher are the same things that make him such a good writer. And so I'm going to talk about a few aspects of the book that represent for me qualities of Lawrence as a teacher that I admire and that I've tried to copy in my own life. So the first is that when you read one of Lawrence's books, it's really clear that for him, the point of writing is to enlighten the reader and not to demonstrate the author's cleverness. You know, sometimes I read, probably some of you have had the same experience, sometimes I read articles or books, especially by law professors, and I think, what function does this serve, right? What have we all gained from this experience? And often the answer is that the book or the article, it seems to be intended primarily to show that the author is very, very smart. But Lawrence's books aren't like that at all. He writes in the voice of a friendly, knowledgeable, often bemused person who just wants to share some of what he's learned for our benefit, not for his. You know, I think it's such a distinctive voice that I think we could pick up one of Lawrence's books and identify him as the author, even if his name wasn't on the cover. You know, and it's the voice of someone who certainly could be showing off cleverness if he wanted to, right? But just has no interest in doing it. And so I think The Walled Garden is a good example. It's a discussion of how ideas of privacy have changed over the years, how they're still changing in a wide variety of settings. It's full of interesting anecdotes that come mostly from court opinions and newspaper stories, which illustrate some broad changes in attitudes toward things like the human body and the proper role of the state. And all along, there are thoughtful explanations of why concepts of privacy have changed. These explanations are voiced not as clever theories devised by a super intelligent author, but as common sense observations. And, you know, it may well be that some readers will come away with the mistaken impression that this book must have been really easy to write, because everything in it just seems so sensible. But, you know, people like us, people who are actually in this business, you know, people who've actually tried to do this ourselves, we know that it wasn't easy at all, right? Because we know how hard it is to impose some sort of meaningful order on this enormous mass of disparate facts, because we've tried to do it ourselves, and we failed most of the time, you know? And so I think of Lawrence's books as being a little bit like synchronized swimming, you know, because it looks so smooth and easy on the surface, because all the hard work is below the surface, where you can't see it unless you try to do it yourself. And, you know, that reminds me of Lawrence as a teacher. When I was a student, there were some other students in the class who I guess had been to graduate school in other disciplines, and because they had adopted the academic way of speaking. They used big words to try to impress everyone. And I mean, I was intimidated because I mean, half the time I had no clue what these people were talking about. But Lawrence had a gentle way of translating their academic language into ordinary English so that the rest of us could see that what they were saying wasn't particularly profound. But I think, I'm not sure about this, but I think he managed to do it in a gentle enough way that it didn't cause them to realize that he was puncturing their balloon. And, you know, and the lesson I took away was that the value of a thought and the complexity with which the thought is expressed are just two completely different things. The thoughts can be expressed simply, or they can be expressed in a way that's hard to understand. If you're trying to impress people with your own intelligence, right, you've got a strong incentive to choose difficult language, because it'll intimidate some readers into thinking, oh, that thought must be really complex if it requires such fancy language, you know. But authors who are interested in actually informing readers, they have the opposite incentive, you know, if they're not interested in showing off. So that's one thing that I've always liked about Lawrence, both as a teacher and as a writer. The second thing I like about Lawrence's books, including The Walled Garden, is that his goal is to understand the world and not to take sides in a debate. You know, I suppose it's not that surprising that law professors generally love to argue. You know, law, it attracts argumentative people. It always surprises me that historians seem to love to argue just as much. You know, that there are lots of books by historians that are populated by good guys and bad guys. And the authors want to prove to you that they're on the side of the good guys. And so they spend a lot of time, devote a lot of effort to showing why the bad guys were bad. You know, and to me, that's just not very interesting. You know, I like to read books about the past because I want to understand why people in the past believed the things they believed in and why they acted the way they did. You know, not because I want to find out whether the author thinks they were good people or bad people. You know, and so just to pick an example that I'm sure a lot of people will be familiar with, an example that's been on my mind lately. You know, there are lots of books that'll tell you that, say, the Dred Scott decision was wrong, right? Or the Korematsu decision was wrong, or pick your famous, you know, bad Supreme Court case, right? To me, that's very boring. Everyone already knows that by today's standards, those decisions were wrong. What I prefer to read is a book that helps me understand why so many people at the time thought they were right. You know, I want to know what was going on in those people's heads, not what's going on in the author's own head. You know, I worry that sometimes people confuse understanding something with endorsing it. Anyway, one thing I really like about Lawrence's books is that they're about understanding people of the past in their own context. They're about the people themselves, not about what Lawrence thinks about them. You know, and so The Walled Garden is a good example. The book is full of people from the 19th century who had all sorts of attitudes that just seem kind of silly today. You know, like the censorship movement led by Anthony Comstock, or the notion that pregnancy shouldn't be visible in public. You know, it's really easy today to deplore attitudes like those, and you can find plenty of books that do just that, but not The Walled Garden. You know, it's clear that Lawrence and Joanna, they're not Anthony Comstock fans, but they don't waste any time telling you why Anthony Comstock was wrong. They don't criticize him or his followers for believing the things they did. Rather, they explain why those ideas seemed sensible to people at the time. I mean, I think that's a lot harder to do, but I also think it's a lot more valuable. And again, that reminds me of Lawrence as a teacher. I was in Lawrence's constitutional law class in my first year in law school. And of course, we read lots of old cases in which Supreme Court justices expressed views that are no longer widely held. And of course, lots of newer cases in which they expressed views that are now conventional. And, you know, and he didn't waste time talking about why the old cases were wrong, or why the new cases are right, or, you know, whether there should be a 3-pronged test or a 4-pronged test or whatever. You know, rather the point was to understand why conventional thought changed between then and now. You know, the goal, again, it wasn't to join in on the debates, but rather to understand them. And I'll finish with one last thing that I really like about Lawrence's books, including The Walled Garden, after I have a drink, excuse me. And that is, you know, in today's world, the thing that's really valuable because of its scarcity is perspective. You know, we all have an infinite number of facts at our disposal. And on some topics, we also have a seemingly infinite number of opinions at our disposal, some more informed than others. You know, and in both respects, the quantity has just ballooned recently, right? We have many more facts and many more opinions accessible to us than anyone has ever had in the history of the world. But the one thing that hasn't changed is the number of people capable of putting all those facts and opinions into meaningful perspective. So the relative value of perspective, of context, is even higher than it used to be, at least for the subset of consumers who actually want it, and I'm one of them. You know, and that's Lawrence, I think of him, he's a purveyor of perspective. His books pull together people and events spread over long periods of time in wide geographic areas, right? So The Walled Garden is a good example. It ranges over a few centuries to show how sometimes things changed and sometimes things didn't. You know, I doubt there's anyone in the world who knows more than a tiny fraction of the stories that the book tells, but even if someone knew all of them, that person would still have a lot to learn from what Lawrence and Joanna make of them, because again, it's perspective that's scarce, and that's what Lawrence provides. And in the hands of just about anyone else, The Walled Garden could have been a very different book, right? So I could think just offhand of two different ways it could have been written, right? So one way is a way that I think would be characteristic of many historians, and that would have been to pick one of the stories in The Walled Garden. It's full of interesting stories. Pick one of them and describe it in enormous detail. Right, that would have been the whole book, just one of the stories. And the unspoken assumption would be that this story is so representative of the place and the time that we can see the world in this grain of sand. We can learn all sorts of things just from this story. Of course, the author would never actually investigate how representative the story really is, because the author's real interest would be in the telling of the story itself. And the lessons we can supposedly learn from it, I think, would mostly be an excuse to tell the story. So that's one way it could have been written. Another way it could have been written is a way that I would think is probably more characteristic of law professors, social scientists, and that is to take all the stories in The Walled Garden and cram them into a single overarching theory that supposedly explains them all, like the way lawyers take cases and cram them into a legal argument, or social scientists take disparate data points and fit a curve, right? And it would, to do that would take an awful lot of twisting and squeezing to kind of force the stories to fit into their assigned slots, but that would be fine with the author, because the author's real interest would be in the theory, and the stories would mostly be an excuse to elaborate the theory. But Lawrence doesn't do either of those things in his books, including The Walled Garden. The world is presented as a messy, complicated place. Our understanding of it is always tentative and partial, never perfect, but always capable of being improved. And the best we can do is just to accumulate as much information as we can and make the best sense of it that we can. So, I've met a lot of people in this line of work who are extremely clever, but Lawrence is one of the very few who I would describe as wise. So I feel sorry. I feel sorry for the Stanford students now who won't get the experience that I had, and I hope his retirement is more just an adjustment of legal status than it is a change in the way Lawrence actually spends his time. I hope it doesn't shut off the flow of new books. So I hope if I check Amazon in another few weeks, I hope I'll see one or two more. Thanks.
I just wanted to say, if someone online asked for people to speak closer to the microphone, so if we can do that, that would be great.
Sure. So, hi everybody. Thank you so much for having me today. Thank you to Amalia and Bernie for organizing. So first, thank you and congratulations to Lawrence and Joanna for this really incredibly comprehensive and insightful book, which is also a really fun read, which I think is really hard to do at the same time, but you did it. What I'll try to do is maybe a little bit differently from my predecessor here, kind of just identify a few overarching themes that stood out for me in the book, and then try to bring them together with one example of something that I think about a lot in the context of privacy-related issues, and hopefully leaving you with some food for thought. So one of the key observations that was already mentioned that Lawrence and Joanna make in this book is that privacy is a social concept, right? That it's defined and interpreted by lay people in their hearts and minds, as you say. And this is an insight that I first learned from Lawrence in his Law and Society seminar. And at the time, now, it's been 10 years since then, so it seems so obvious that everything is, a social concept in the law, right? A lot of things are, these relationships between law and society are so intertwined. But I don't think that's obvious to a lot of people at all, where that, a lot of people think about the law as sort of in and of itself, right? That only experts are the ones in charge of understanding and defining it. And I think that's such an important observation to make, really in keeping with this law and society tradition that Lawrence has been such a leader in. And especially with this new strand of experimental jurisprudence, which really calls for examining how lay people understand and interpret legal concepts like privacy, as opposed to this traditional approach of only looking at the law in and of itself. So how do lay people understand privacy? So Joanna and Lawrence suggest this duality, which is really central, I think, to the book. On the one hand, privacy as a duty. Certain aspects of life should be kept private, right? Certain language, certain content are sort of understood as taboo and should be kept under wraps, as opposed to privacy as a right, something that people can elect and be protected by. And as Joanna and Lawrence point out sort of later in the book, there's some tension here. Because even though most people want the choice of being private, sort of keeping to themselves certain information, like where they live, for example, they enjoy others sharing information, right? They're enjoying others sharing their private information in a more public way. So people don't actually want all taboo information or content out of the public eye. They only want their own private information being kept private. Which leads me to a next really important observation that I think that comes out of the book, which is this distinction between what the public wants to know, the desire to know certain things, so things like gossip, right? Things even that even have sort of titillating value, right? Or voyeurism when it comes to especially celebrities that Joanna and Lawrence sort of explore in the book. And then what is in the public's interest to know? What is actually this idea of the right to know actually means? So things like the medical information of somebody that has a contagious disease, that could be in the public's interest of knowing, or information about government agencies, right? They explore FOIA requests in that context. And sometimes the lines are a little bit blurred between what the public wants to know and what is actually in the public's interest to know. And one example that I really like that you bring up in the book is about David Beckham's daughter's pacifier, which was apparently slapped all over a tabloid in the UK. And Joanna and Lawrence say about this, and I quote from the book, "It is assumed, of course, that the public has a right to this information, that they care about it or are fascinated enough by it to override any notion of Beckham's privacy rights." So I was struck by this example in this sentence in the book. And it got me thinking about what is the desire to know, does the desire to know certain things necessarily give rise to a right to know? The fact that we want to know about David Beckham's life or children, how he raises his children, does it give us a right to that information? And I think this question is tricky because, as the book teaches us, we are dealing with two sort of contradictory forces here. On the one hand, an increasing desire for privacy, so people want to keep, they're nervous about their private information being out there and accessible, and they want to keep it to themselves. And we see it with things like HIPAA in the health context, and we see it with this reaction to massive surveillance in the government and in the government context. But then on the other hand, more and more demands for us to share certain information, to disclose certain information. And Lawrence and Joanna nicely characterizes these as sort of anti-privileges, where we're actually required to disclose certain types of information. And all of this is happening while, as it was already mentioned here, technology makes private information public anyway, right? So even if we want certain information to be kept private, it's just harder and harder to keep it private. And again, quoting from the book, "A world where a secret life is less and less possible, where all private selves can be exposed." So I was especially intrigued in this context by Chapter 4 about the privilege of silence and Chapter 5 about privacy and choice, which I thought pointed to this key tension that we have in modern society between the interest of having certain information out in the open, because whatever you call it, it's in the public interest of knowing it, or it's within the public's right to know, and the individual interest in privacy, in keeping certain information under wraps, or having this reasonable expectation of privacy, or as Lawrence and Joanna call it, a right to elective privacy. And I think we see an example of this in a topic that I've personally have become really interested in recently, which is confidential settlements. So the issue of confidential settlements has become salient recently. I'm sure you all heard of it with the Me Too movement, but it actually has a long history. There was this public outcry back in the 80s over defective products like breast implants and certain prescription drugs that had all sorts of side effects and dangers, but these were kept under wraps because people kept signing these hush agreements. So they were paid essentially for whatever harm they suffered, but none of this information found its way to the public. And unlike FOIA laws, which Lawrence and Joanna talk about, only some states, like Florida actually is one of them, and Louisiana, restrict these types of confidential settlements, these NDAs, in these types of statutes that are commonly called sunshine litigation laws, and really make you disclose settlement information. And these confidential settlements, it seems to me, are really pitting the individual right to privacy against risks to third parties, right, or to society overall as a result of keeping certain information about wrongdoing private. And this relates to the discussion in the book regarding the duty to warn third parties. So Tarasoff, a famous torts case, which I'm sure you're all familiar with, identified kind of a vague, arguably, duty to warn, at least when the danger is to a particular person, and there's concrete, reliable information about an intention to harm that person. But what about a broader duty to warn, which sort of overrides the individual right to privacy, which really prevents people from keeping that settlement information, for example, to themselves, especially when it comes to people that are sort of repeat wrongdoers. So think about Harvey Weinstein, right? Think about General Motors, think about big pharma companies. And it may be the case that certain plaintiffs actually, want this privacy. They elect this privacy, right? They want the information to be kept, and it is their choice, and they're exercising their rights to elective privacy, as Joanna and Lawrence explained to us. But is that really their right to keep that information to themselves when it's information that is in the public's interest to know? That is within the public's right to know, whatever we define it. And shouldn't there be a duty to disclose that kind of information? I think one of my favorite quotes from the book is when Joanna and Lawrence say, "Crisis trumps privacy," which I think is a crucial observation about the tension that we've been talking about, right? This tension between certain information being kept private and certain information we want to be out there, out in public. But what does it take for a phenomenon to become a crisis that really justifies this crackdown on a cloak of secrecy or privacy or confidentiality that covers that topic, that keeps certain information from the public eye? Think about police misconduct, for example, where you can still have these types of confidential settlements. You can still settle sort of outside of the public eye and really keep this information secret. Aren't we there yet? Isn't it a crisis yet that justifies more information being made public? A final question that I want to leave you with before I end. So in Chapter 4, Lawrence and Joanna discuss this requirement of confidentiality that certain professionals have. And many of us in this room are lawyers or going to be lawyers. And we will have this kind of requirement, right, to keep certain information confidential, certain information that our clients tell us about. But what about a commitment that lawyers have, a broader commitment that we have to society, right? Doctors too, right? It's the same. Doctors with patients or psychiatrists, if we think back to the Tarasov case, not just to our clients, right, but also to society more broadly, that maybe should get us thinking about a new exception to this confidentiality rule or to the existing privileges, or maybe expanding the existing exceptions so that we are able to share information, even though it was disclosed to us by a client, but it's an information that needs to be in the public realm, that needs to be known to people, that shouldn't be our clients' elective privacy, should actually trump individual privacy in some situations. So just leaving you with that final point to think about. And again, congratulations on this fantastic achievement, and I really look forward to that discussion.
So, Lawrence, would you like to say a few words before we take your
yeah.
answer?
Yeah. Define few. So, first of all, I think it's my duty to say thank you to some people. First of all, thank all of you for coming. And I want to especially thank the panel for taking the time from their busy schedules. I hope they're busy. To come out here and to talk about this book. And of course, I especially want to thank Joanna, my collaborator. It was really fun to work on this together, and I really liked the remark that it's hard to tell who wrote what sentence and so on. Of course, I wrote them all. No. It was a real collaboration, and it was fun. So people have said very nice things about the book, and there's always the hope that people want to go out and buy it, but as soon as they start, they'll find out that it's incredibly expensive. We had no role in setting the price, so if you're frustrated, you can buy one of my mysteries, which are very cheap. And I want to thank Amalia, and I want to thank the staff and the people who put this together. I know it's Bernie. It's been a big pain, and I hope you feel it's been worthwhile. So I don't want to go on and on, but I want to make a couple of points about what this enterprise is altogether. Of course, it's a law and society, but it's legal history, but it's also a law and society book. And, we're believers. It's like a religion. We're law and society people, and conventional legal education has always been capital T, capital E, the enemy. But it's like a lot of people that have deep faith. We don't know, why isn't everybody with us? And I want to say thank you to two people and tell you why I'm thanking them. One of them is Stuart McCauley, who's not here, but I think might be following this on Zoom if that's possible. And Stuart, who was my friend and collaborator many, many years, at the University of Wisconsin, and he's a graduate of Stanford Law School, actually. And he wrote an article in the 1950s, which is, I think, the single most cited law and society article ever written. And it was about he's a contract teacher, it was about contract behavior in Wisconsin. And what Stuart did was he went out and he talked to business people in Wisconsin. I mean, that's it. I mean, that is what was path-breaking about the work. And that's why it's been cited thousands of times and has had whole symposia. Because that wasn't what law professors did. You didn't go ask, what do you actually do? I mean, here's a rule. Here's a case. Do you know about it? Do you do anything about it? So it's very simple. The idea is just blindingly simple, but people hadn't done it. And the other person I want to mention is my late colleague, John Henry Merriman, who's here at Stanford. In 1950, which is a really long time ago, he wrote an article called The Authority of Authority, in which he looked at the California Supreme Court decisions and he counted the things they cited. And he just, again, it's just a blindingly simple idea, but nobody had ever done it. So, we talk about the way courts behave and their citation stuff and so on, but he actually looked at it. And so these are inspirations, and it's been an inspiration to me in my work, a lot of which is empirical in a very crude way, or sometimes not so crude. I'm very, very pleased to have Robert Percival here, who was my collaborator in 1981, that's a long time ago, a book we wrote about crime and punishment in Alameda County, California, in which we looked at all kinds of old records, old bail bonds, court stuff in the very dusty basement in Oakland. But, again, I think the idea of doing this is just not something that would get you a Nobel Prize in physics, but nobody had done this. And what we did, I think, is we drew a picture of what criminal justice was like in the late 19th century in Alameda County, California. And I think to this day, no one has ever done anything quite like that. Okay. All right, well, I won't go on talking about my own work. I want to mention one thing, though, before I stop, about the walled garden. I think one of the things in it that we are, I think, most proud of is, I think that we say something about celebrity society. We live in a celebrity society, and there's a huge literature on celebrities, all of which misses the point. The point of celebrity, it's not being famous. Queen Victoria was very famous, but she wasn't a celebrity because she wasn't familiar. A celebrity is someone who is famous and familiar. And that's a product of television, above all. That is, we think we know these people because we see them every day. Harry and Meghan, or the late Queen Elizabeth, they are celebrities. The Pope is a celebrity. The Pope used to be locked up in the Vatican. The Dalai Lama is a celebrity. It's the familiarity that does it. And this has enormous consequences because it also feeds and leads to a number of things. One thing, the question of what is the privacy right of celebrities. We spend a lot of time on that. It's a very interesting subject. It's different in the US, apparently, from Europe, but my feeling is they're growing closer together. And also, the fact that you sit in your living room and you see the Dalai Lama somehow breeds in people the notion that you have a right to know everything about the Dalai Lama or the Queen or Harry and Meghan and so on. So I think that the discussion of privacy and celebrity society is really something crucial for understanding what our world is like. And I think Joanna and I had a lot of fun, but also I thought we thought we were talking about something important, which isn't, dare I say it, wasn't fully recognized by the existing literature, and still won't be, because who the heck is going to read our book? Anyway, thank you. That's it.
So we have about 15 minutes for questions and comments. Also, if you're online, just put a question in the Q&A function online. So, floor is open. Yes?
I think I'm Margaret. Lawrence, I
Oh, for Kindle, $40, but if you actually wanted the book, it's a lot more, yes.
But it was a comic class and I got up early, so you may have talked about this. What I'm interested in is the national difference between the perception of privacy. And it seems to me it's no accident that in the United States, this definition of privacy is based on Roe v. Wade on autonomy. It's essentially a question of autonomy. But under German law, it's a question of intimacy. And intimacy has been already protected in the Constitution. The German Constitution starts out with the dignity of man is inviolable. And the second article basically establishes privacy itself to generation. And what's your explanation, sort of economically and technically and so on? Those societies are very alike. What do you have to say about the national differences with the definition of privacy? Oh, sorry, too late.
So Manuel also mentioned this issue, the comparative issue, and it's terribly important, of course, but you know, for example, apparently there's a big literature on Japan written in Japanese, but you know, we
Perused it.
You perused it.
I don't want to disagree with you. And also, you know, you are a tremendous expert in this area, and of course, I'm a rank amateur. But my suspicion is, and that's one reason why I don't want to go into it very deeply. My suspicion is that yes, there are differences, and the differences are reflected in court cases and in legislation, but that these are, my feeling is they're diminishing. And that, you know, people are divided, scholars are divided into lumpers and splitters, people that are interested in big generalizations and people that are interested in small differences. And they're both important. I'm a lumper, and one of my big things is convergence, that the societies of the world are growing closer to each other. And you know, I gave a talk in Poland a number of years ago and then had to prepare a talk. And without going into why this was important, I looked up the list of I think it was 100 best restaurants in Warsaw. And it was interesting, the question of how many of them serve Polish food. I have nothing against Polish food, never having eaten any.
Are you from Chicago?
But of course, it was a small minority. And having been in Tokyo, where there are plenty of Hungarian restaurants, Italian restaurants, and so on, I got very interested in the sociology of food, which I won't rattle on about, but just the spread of sushi, the spread of pizza, and so forth and so on. I mean, there is a kind of cultural convergence, and it seems to me, not knowing a lot about it, that if you look at Europe, yes, ideas of privacy, protection of privacy, data protection, and so on, are different, and in many ways more advanced, and the cultural reason you suggest might have something to do with it, but that they grow closer together. I mean, for instance, we have People magazine, but you have equivalents in Europe as well, in Spanish, in Italian, in German. And the Celebrity Society exists there too. One of the things that I wish I had really kept a copy, but I think it was the Bild Zeitung in Germany once, this was many, many years ago, had a picture of Prince Charles on the front page, a surreptitiously taken picture of him in the shower. And the headline, this big, was Charles Knocked, Charles Naked, as if there was anything special about his equipment, which you couldn't even see. But this really struck me. It's really struck me. This is, and I think that was, I think that magazine has gone out of business. You know. By the way, let me put in a plug for Inga's wonderful book, since she's sitting there. She has this marvelous book. You know, Inga was the U.S. leading authority on a field that no longer exists, the law of East Germany. And so she had a crisis, academic crisis, when her field disappeared. And she became a legal historian. And she found an archive in a small town in Germany that had records, a lower court that had records back to right after the war. And then she wrote this marvelous book about what it revealed about the life of the law in this little town, well, not that little, but a relatively small town in East Germany from about 1946 to the end of the East German legal system. And, you know, frankly, I don't want to preach, but I think that's what law professors ought to be doing. Instead of writing a 100th article on a new theory of the 14th Amendment, which no one is going to read, and no one is going to pay any attention to. I mean, no one pays attention to what we do either, but at least they enjoy it. Okay. Yeah.
I think I saw some other questions from Margaret. Yes, please.
Thank you very much, Jacqueline Stewart, and I love hearing you again, Professor Friedman. You're still Professor Friedman to me. But I have a special request for your next book, How Disinformation and Privacy Work Together, because the arena is so flooded with disinformation. Not that it's anything new, because it's been going on for the last 2,000 years, at least, but how does all that work together, and should legislation be developed to address this, because it's done so blatantly now, possibly? Should something like estoppel be designed more specifically to deal with disinformation and the people who intentionally do it, and the whole industry that is out there doing it? Thank you very much.
You know, I wish I could answer that question. I mean, I think what you say is really important, and I'm sure practically everyone in this room, maybe everybody, is worried and upset about the flood of misinformation. But it's not just, I mean, misinformation has always been out there, but that people believe it, that it spreads so fast. And you know, this is, modern technology is to blame, of course, because ideas, habits, customs, and even lies spread in nanoseconds all over the world. But also lying behind this is the decay of respect for authority. Not just, I'm not talking about political authority, but intellectual authority. You know, people who just don't believe in science, who don't listen to a doctor, who just feel that, I mean, there are lots of people, I don't know how many, who think that there's some colossal world conspiracy of scientists for some unknown reason to tell us that the climate is changing and this is terrible. Now, again, the technology spreads this, but the underlying problem is attitudes toward knowledge authority, and this has obviously declined. I don't know why. And it also, I don't know, someone once said something that I found very interesting. We talked about the Lincoln-Douglas debates in this country, very high level. And the question was, who was the audience? And it was a bunch of farmers in Illinois. Now, they weren't educated people, particularly, but they respected the kind of debate. And then, nowadays, in politics, when they say, well, you have to have a slogan or it can't be more than 10 words or whatever, the fact is that patience and respect for intellectual authority has declined. I don't know why exactly, but I think it's a fact that it has, and it's very dangerous for the world. But, hey, nothing I can do about it.
Other questions? Yeah.
Hi, Lawrence.
Hi, Malcolm.
I wonder, you're a lumper, and I've known that for, 50 years. And I've gotten lumps from you as well. But I wonder if what you think about a theory, a general theory that you might reject, that is that privacy, the lack of privacy has been curvilinear. Think of simple societies. Think of what the anthropologists tell us about community life. Everybody knows everything. Think about Red Schwartz's classic article comparing the kibbutz and the moshav, where there wasn't the need for any law in the kibbutz because everybody knew everything because information was passed in the communal showers and dining halls and so on. So is the concern with privacy something of a 19th century Victorian thing that was prevalent, that is no privacy was common in simple societies, small towns, tribes, and so on, and then through the modern society, we've reached the same end of transparency everywhere and little privacy?
Well, there isn't. Yeah, okay, so that I have to think about this curvilinear theory. It's very hard to do that off the top of my head. I don't do curvilinear very well. Anyway, this afternoon's book is about one of the issues there. That is, okay, in the village, not just in the Kfutza or the Moshav, but in the traditional village, let's say, yes, everybody knows everybody, and there's a lack of privacy. Also, there's a lack of privacy, if people live in huts with their family there, plus chickens and dogs and so forth and so on. And that has a lot of consequences. But then you come to the big city, and while there's still poor people are living in a very cramped, non-private situation, there's the big world out there. When you go out in the street, then you have, if not privacy, you have anonymity, as Joanna explained. And that's diminishing, definitely diminishing. And so if your question is what are the consequences of these changes, I think that in our book we talk about a lot of these changes, but I think we're careful not to say where it's going, because we don't know where it's going. Nobody knows where it's going. We do know that as technology alters the world, that the law and also the structure of society also changes. So the technical right of privacy, which is conventionally ascribed for its beginning to Warren and Brandeis in the 1890 article, The Right of Privacy, in the Law Review, which came out of some school in Cambridge, Massachusetts. I forget the name. But so that was the beginning of the right of privacy in one technical sense. They set out a theory and said the common law really has the equipment to do this because, and they cite a bunch of minor cases, and they try to weave them together. It's a very clever article. Now, lying behind this article, for example, is a technological change. So Warren and Brandeis were well-to-do, upper-class people, and they were horrified by the yellow press newspaper of the day, the mass media of their day. And they were particularly perturbed by one thing which is mentioned in the article, and that is the invention of the candid camera. So in the 1880s, before that, the camera couldn't capture motion. So in fact, if you went to have your portrait, which was very popular, you often had to sit with a clamp around your head. That's why in the early photographs, they always look like they're sucking on a lemon, because you can't say cheese for half an hour. Well, then along came the invention of the candid camera. And this was a great advance. It was very good. People bought these things. They were cheap and so on, and they were terrific. But one consequence was that now, for the first time, your picture could be taken without your permission. And Warren and Brandeis mentioned this fact, and it's a perfect example of how technological change leads to cultural change, which then is reflected in the law, which, by the way, is the theme of my next book, which is in press now. Anyway, that didn't answer your question, but that's because I couldn't.
Well, I think we have time for one more question, so I see Mr. over here.
I was interested in the beginning when Joanna said you intentionally omitted this concern with constitutional law. I wonder now, since Dobbs came out, since the edition of this book, in your next edition, how will you approach that decision, its history, and what it means to the ordinary person? And related to that, what consideration would you give to Supreme Court justices as celebrities?
The next edition? Ha!
Motherhood.
Motherhood. Joanna, do you want to comment on that? No.
No, this is your day.
It's my day. I think by the way, one of the reasons we left out the constitutional right of privacy is that in many ways as it's been pointed out over and over again, it's not really a right of, quotes, privacy. It's a right of making certain choices in certain areas of life, which they call a right of privacy. And of course, these things like sexual behavior are private in one sense. But so we didn't take that up, and I don't think we have any plans to talk about it in the future. But obviously, what happened with Roe v. Wade and so on is very interesting in any one of a number of ways, and it is, of course, important, but it's not so important with regard to the things we did talk about. Now, I'd be happy to discuss what I personally think about it, and I've actually been writing about the history of abortion law, nothing that's been published yet, but I think that what you have here is interesting in so many ways that one can hardly exhaust it. You know, we could have a whole course on it. The use of history in the opinion overturning Roe v. Wade is, of course, completely bogus. It's a complete misunderstanding of the actual history of abortion. The real story here is about the evolution of ideas about sexual behavior. That is, underlying the anti-abortion laws in the 19th century was a code, the classic sexual code. And what was really evil about abortion was it's surprising how little religious talk there is in the anti-abortion movement in the 19th century. What it is about the shame that abortion, a woman who has an abortion and a woman who uses contraception, is hiding or trying to hide the fact that she has had illicit sexual intercourse. And this was the big sin against which the abortion laws were directed. That, not the only one. I mean, there's also tremendous health dangers from the techniques that were then used and the number of women who died or seriously injured. But running through the literature then has to do with attitudes towards sexuality. And so the modern anti-abortion movement is entirely different because it reflects an entirely different way of thinking. Now it's primarily religious and moral, and no one cares. No one seems to care that people are having illicit sex. I mean, the irony is that the Right to Life people come up to a woman and say, we want you to carry this baby to term. And they don't care that the baby would be, quotes, illegitimate. That's of no interest whatsoever. Well, you can give it up for adoption maybe, but the fact that you sinned to have it, it just is not a factor. And at any rate, this is just part of the story. So I think that there could be a very good study done, which we haven't done, and I don't think when I talk about the next book, we're not talking about that subject, but what does the whole history of the way the law treats matters of reproduction, sexuality, and so on? There's a big literature, but somehow, of course, people always say this. Does it mean we could do it better? No, but we could do it differently, I think. Should we do it?
Today? This afternoon?
Yeah, this afternoon. Yeah. By the way, that was a pedagogical point because I actually didn't answer your question. I don't know if you noticed that or not. Well,
You're getting good at this, not answering the question.
no, listen, I've been teaching. I taught for over 50 years here, and and that's one of the things you learn.
Not to answer.
When a student asks a question you can't answer, how to answer it without answering it.
Well, I think now that we've heard about your next book and the potential second edition here, we could wrap up this panel. Thank you all so much for coming, and thanks again to the presenters. Come back at 1:15 for another session on Lawrence's most recent book, at least that we know of. Thank you.
Joanna, you were great. But you were great.